Why don't you give us
And then Chief Justice letters are here, and some letters of support from some other organizations.
just one of those, actually.
Okay,
We just have one more.
Oh, sorry. Of course.
Very
Shannon Irwin.
Yeah.
Thank you for your stamina hanging on this long. The 2 points that I just wanted to underscore were one, Virginia, Professor Benzon's point about the bipartisan nature and the broad support. I think it's a rare opportunity for us to move forward with something that would benefit both our court system and making things more streamlined and easier for them, but also would benefit a population that our Congress has clearly stated it intends beyond the pathway to apply to the federal government for citizenship. And whatever our views on what to do with the undocumented population, I think one thing that I hope we can all agree on here, I hope we can agree on, is we shouldn't artificially preserve a larger undocumented population than we need to. If there are folks who the federal government has stated unequivocally they want to be on a pathway to citizenship, we should allow them to simply go through the process and file the paper. So we feel like this is a great opportunity to do that. The other thing I would say is, and again to Attorney Magnus' point that this is the 7th year this has been filed, it is a time-sensitive bill, and of course every piece of legislation is time-sensitive in a way, right? We would always want to move more quickly on measures that are important and needed, but in the case of this bill, we've already seen in 7 years more than 2 cohorts of youth who would have been affected now no longer able to be benefited, and each year that goes by we lose perhaps another 40 or 50 youth. Not a large number, not a number that we've heard in our courts, but for each individual it can make a life-changing difference. And so for that reason, we were really asked that you report this bill out favorably. We're so grateful that you did so last session, and subsequently also was reported out favorably by House Ways and Means and by Saving Policy. And if you would be in a position to do so in a way that prioritizes time, we would be so grateful. We know that you have more work than any other committee in the legislation. So
Thank you very much for your testimony. Thank you all. Thank you for volunteering to this. Michael, this seated is John. Matt Michelli and Carl Zabel. I just want to do a slight apology to you guys because I realized that you were here to testify on the matter of the Virginians were testifying on that from time ago. Jim Fernandez, thinking like an attorney, said, "Can you put these guys in?" And I said, "No, let's keep everybody in order." If I'd known how long it was going to be, we got back to it, it didn't matter.
It's all right. It's important if we don't mind.
All right, thank you.
I don't think that. I think this went longer than Tom Brady there. Chair Brownsberger, Chair Fernandez, and Drew members, thank you for the opportunity to testify in opposition as currently drafted to Senate Bill 758 and House Bill 1287, acts relative to decedent email access. My name is Matt Michelli. I'm the Northeast Region Executive Director for TechNet. I live north in Boston. TechNet is a member association made up of CEOs and senior executives of over 70 of our nation's leading high-tech companies. Almost all of our members are either headquartered here, have brick and mortar here, employ hundreds of thousands of people in the state, or do millions of dollars of business with the Commonwealth. Our membership agrees that personal representatives should have legal mechanisms to ensure that they can obtain the information they need to settle their estates. TechNet has been working with industry and privacy groups across the country to support a solution that provides a pathway for estates to obtain the information they need while also respecting users' privacy expectations and our obligations under federal law. It is a comprehensive, consistent solution that is broader than just email. It covers all electronic communication. We look forward to discussing this solution with members of the committee. Carl Zabel with NetChoice is here next to me. His group helped draft the alternate language that could provide a solution that all sides are looking for. It should also be noted that individual companies are also responding to this issue with innovative user choice tools that provide consumers the opportunity to decide what happens to their account information when they die. As tech companies mature, so do their consumers. Companies are responding to their consumers' desires by making tools available to mass residents that don't require legislation to be effective. These tools should be allowed to evolve and adapt to their consumers' needs and wants. Thank you for your time and consideration.
Mr. Chairman, Mr. Chairman, representatives of the committee, my name is Carl Zabel. I'm Policy Counsel for NetChoice. Today, federal law does not require service providers to disclose contents of your electronic communications. And we fully agree with the sponsors that Massachusetts should fill the gap to help settle an estate. To that end, we are working to advance a solution created by industry and privacy groups like the ACLU, the Electronic Frontier Foundation, Center for Democracy and Technology, and Consumer Action. It's an approach that is now law in Virginia and has passed out of the House in California. Our alternative can get to what is called the outside of the envelope, the records of communication by default, and then it can allow fiduciaries access to the inside of the envelope after there is express consent in either a will or user choice mechanism. The solution has procedural safeguards to protect user privacy and ensure information is not turned over to anyone who shouldn't receive it. And we look forward to working with the sponsors, the committee, and other representatives as we discuss and hopefully move this alternative approach.
Questions from members of the committee?
I do have just a couple of questions in fairness, and I appreciate the length of effort you folks have gone to and matured into in terms of this discussion over the last several years, because I went through this late myself, but I do find it a fascinating issue. The only two questions, getting tired. When the Janies were here testifying, they mentioned two things that struck me. One had to do with the fact that similar legislation has been passed in a number of other states, as you had mentioned, Virginia and California, and you're looking at the legislation that you guys are working on. While I do think a national solution makes some sense, they mentioned that those pieces, those states have, several states have acted on it. Are you aware as to whether that legislation has caused any problems in terms of its interaction with federal law in the states where it's happening? And the other thing they mentioned with Microsoft 699 was that Microsoft and at least one other readily allow access now. Has that created problems in terms of federal? So if I were to say, hey, I love the fact that you guys are talking about a solution nationally, maybe globally, that handles all of the different facets of electronic communication, but my world right now is emails, and I want to deal with emails while this solution is coming together. We have some precedent with emails that have to do with other states, Microsoft and one other provider, that was. Why haven't there been problems in those situations? I have been.
So, thank you, Mr. Chairman, for the questions. To address your first question about other states with different approaches, one state, for example, says, just a couple of words, the fiduciary shall assume essentially the fiduciary shall assume access to the estate, to the electronic account. Have there been court actions? No, because there has not been, to my knowledge, any request made under those laws to get access to the electronic communications. I can tell you that if there were such requests, the people making the request would be sorely disappointed because it's unlikely that companies would risk violating federal law and there would be lawsuits. Our goal is to avoid going to court. Our goal is to create an alternative that gets around that issue. To your second question regarding Microsoft, I'm not entirely sure how recent the privacy policy or disclosure purposes that Mr. Dean looked at. He was citing Hotmail, and Microsoft no longer offers that service. Microsoft's not a member of NetChoice, so I can't necessarily speak to what they do. But if, as part of the terms of service privacy policy that you agree to when you sign up for their service includes the right of a next of kin to get access, then that may constitute the express affirmative consent required under federal law, and Microsoft may feel comfortable doing that. Other services may want to set the default at privacy, where your emails are protected unless you make an express opt-in to disclosure. So you have different services approaching differently the way that electronic communications are disclosed after some time.
So if we actually then pursued legislation that simply mirrored what Microsoft is doing, would we be in unstable, would we be on unstable ground?
So, on a legal issue, I would have to sit back and think about that.
Yeah,
But
I'm not,
Right.
these are really for thought.
Right, but so one of the things that NetChoice did is we actually commissioned a poll of 1,000 registered voters across the country and asked them pretty bluntly, who should get access to your digital accounts when you die. The polls and all the crosstabs are available on our website. And essentially 5 to 1 voters said that unless there's an express consent, that nobody should see their own communications after they die. So, and that kind of makes sense if you think about how we use electronic communications today. We send the most intimate of communications and we treat them much more akin to a phone call than we do a letter. So it's our view that they should receive the same type of privacy protections that we have for a phone call, that rather than what we would for a corporeal form of communication.
So isn't the second question that we've asked them is, well, would you like the option to be able to either exercise that consent or would you prefer to not have the option? It sounds like the Microsoft approach is the one that I prefer, which is that you have the option as opposed to some other company that doesn't give you that option.
Well, clearly, let's have a little discussion because I'm interested. Clearly, everybody says, is going to say, if I express, it should be up to the person. So the question of, if the person has one wish, then that's what it's going to be. If they have a different wish, then that's what it's going to be. That's, the only question is what happens, what sort of default, right?
Well, that's what I'm asking is, because when you say, who do you want people to have access to it, it's going to be 5 to 1 only by consent. You don't ask the second question, is would you like an option? And Microsoft offers that option, other companies do not.
What's Microsoft's option if they don't?
Microsoft is a vendor of TechNet, so I will try to get some information and get back to you on that.
Okay, yeah, so that's what I'm saying. I'm just looking at it from a very narrow scope, is that if I wanted to do something tomorrow, and I'm going to, but the worst case scenario that I would be on some stable ground, because I kind of think, like Mr. Tinian, that Microsoft is probably not taking too many chances out there, that if they've got a policy that says you can opt in, you can opt out, that's probably on legally stable ground. And if I said everybody who does business in Massachusetts on emails has to have an opt-in, opt-out policy, I'd probably
Let me understand a little bit what your suggestion was about the envelope. Now, and presumably you're going to apply that to sort of, the directors, I think you were talking like a Google Drive or something like that. Give me that again.
So the federal law, which is the Electronic Communications Privacy Act, which is the federal law in point here, forbids service providers from disclosing the contents of electronic communication without the express consent of either the sender or recipient. It does not
both or just
or one or the other. What it does not discuss are what are called records of communication. And
so like what the NSA captures for cell phones.
I don't know what the NSA is capturing.
No.
But
They were saying,
yeah, it would
they were
be.
saying, we know what the question was. They have the database that affect the envelope information.
Essentially, it's the to and from lines
Yeah.
and timestamp.
Yeah.
And so the federal law ECPA is silent on that. So we do
Federal
not
law is silent on the envelope information.
on the content with respect to voluntary disclosure to non-federal law enforcement, to non-law enforcement entities. So, right. So essentially, the reason that I said outside the envelope is the easiest way to think about it is with respect to a mail courier, they can look and see the return address and the destination address. That is the information that we are allowed to disclose regardless of consent. So what we are suggesting as part of the Peace Act is today we are required not to disclose anything. We have sat down with privacy groups and really tried to address the situation and said, okay, what can we disclose without having express consent? Well, we can disclose records. And what does that mean? That means that when I die, my wife could see that every month I received an email from Wells Fargo, Fidelity, and Comcast. She could then get on the phone with Wells Fargo, Fidelity, and Comcast and say, turn over the money, discontinue the service.
Okay, so, all right, so you're saying the default, regardless of whether somebody actually gets around to making a decision, is you can disclose that.
That's correct.
Now, in the case where somebody has not made a decision, but now they've reviewed the envelope information, the decedent has not made a decision, somebody's reviewed the envelope information, I want to see what's in this email, then what happens?
We are not allowed under federal law to make that disclosure without express consent.
And so then you just wouldn't get it.
That's correct.
And your position is that if I'm appointed as a personal rep, standing in the shoes of the deceased, I am not in a position today to grant that consent. You don't feel that that is consent or has not been established at least in this report.
Right, and it's not just our opinion, it's been decided in a court in California recently, as well as the American federal court. And the American Council of Trust and Estates Attorneys, ACTEC, it's a lobbying arm of T&E attorneys, recently sent a letter to Congress saying, ECPA has caused us problems trying to get access to contents of deceased electronic communications. Can you please amend it? So it's not only our opinion, it's not only the courts, but the lobbying arm of Trust and Estates Attorneys clearly sees a problem with ECPA as providing a barrier for their access to electronic communications without consent.
And did that federal case, I'm sorry, we didn't follow on that, did that federal, I'm not sure what the citation is, the Senate was like.
Well, yeah.
Does that federal case specifically say that a PR is not standing in the shoes of the deceased for consent under the Privacy Act?
So the federal case gets more to the issue of what constitutes consent, and the court is very clear saying consent cannot be imbued, it cannot be posthumously granted, it has to actually come from the individual themselves. So the issue there is, even if somebody is declared to be standing in the shoes, they are not considered to be the individual for purposes of consent under ECPA. I know it flies in the face of every trust and estates attorney and everything that you've grown up with, but that's the way that ECPA was written back in 1986.
But that last piece you just said, that therefore the PR isn't in a position to give consent, did they go that far and make that finding in the federal case?
I will go back and double check it, and I will send you the whole case.
I'll settle down, everybody.
Thank you so much, sir.
Thank you very much. All right, I'm glad we wouldn't have had as much discussion if we did it at 3 o'clock, so we appreciate that. Thanks for coming in. All right, so I'm going to just rattle off a few names who I believe have actually already testified in the panel that we would Shirley Mitchell, Lydia Brown, Ann Housley, Lori Fortin, and Paula Thompson. Nobody responding. Is David Castle still here? I think his testimony is in line with some of the testimony we actually heard. Christy Vine? Oh, you testified. You're all set. Then this is, you done.
I'd love to speak on Christina's law.
No, we're not going back there.
I think you did.
Well, I tried to with Baby Bella because it was the same circumstance, but.
I think you did. I think your message, you got through.
You got it?
Your bluntness was effective.
I tried to talk fast.
Yeah, no, you're done good. Kyle Shaw? Paula Mackin has testified. She signed it twice. John Schlickman? And, oh, Paul, no, those two. Yeah. John Schlickman? Elmer Simon? Anybody still here wishing to testify? Well, yeah, I guess that would happen. Now that I have it. All right, well, thank you very much for hanging in.